Community property. General presumptions. California is a community property state. All property acquired during the marriage by either party is presumed community property, CP. Property acquired before the marriage by gift, devise, or request is presumed separate property, SP. Upon divorce, community assets are divided equally, barring an agreement otherwise. Separate property remains as such. Quasi-Community Property, QCP. Property acquired while couple was domiciled elsewhere, which would be CP if they lived in California. QCP is treated as separate property, SP, during the marriage, but treated as community property, CP, at divorce or death. Take a note, California has no jurisdictional over real property in another state upon death. Source of funds, tracing, commingled funds. Source of funds for initial characterization, the burden is on the SP proponent. Property which can be traced as SP will remain as such. Property which cannot be traced is CP. Termination of marital economic community, MEC. Expressed intent to end marriage and conduct consistent with such intent or when either spouse dies. Non-married couples, unmarried cohabitants, boyfriend, girlfriend, etc. Contract law applies. Putative spouse. If a marriage is void or voidable, the party who believed in good faith that the marriage was valid is a putative spouse. Property acquired during the union is called quasi-marital property. Transmutations, since 1985, are not valid unless made in writing and consented to by the adversely affected spouse. Exception. Gifts between spouses of a personal nature which are not substantial in value considering the marriage. Debts and creditors. Credit acquisitions during marriage equal CP debt. Rebut with intent of lender who relied solely on SP earnings. Timing of debts. When obligation occurred, contract formed, tort occurred, etc. Order of debt satisfaction. For community interests, community property first, then debtor spouse separate property. Separate property interests, debtor spouse separate property first, then community property. SP debt incurred before marriage. Debtor spouse SP and CP are liable for a debt incurred by either spouse before or during marriage. The SP of the non-debtor spouse is not liable for a debt incurred by the debtor spouse before or during the marriage. Non-debtor spouse's income may be shielded in separate account, not commingled, and not accessible by debtor spouse. Exception for necessities of life, even post-separation, food, shelter, and medical expenses. Reimbursement. If CP used to satisfy premarital debt and SP available, CP is entitled to reimbursement. Injury, damage caused by a spouse to a third party. Benefit of the community, community property first, then separate property of the tortfeasor spouse. Not for the benefit of the community, SP of the tortfeasor spouse first, then CP. Personal injury recovery from a third party. During marriage, CP. Death while married, CP. After permanent separation, divorce equals SP. Reimbursement to CP for expenses is allowed. Personal injury caused by the other spouse. Exhaust tortfeasor spouse SP first, then CP. Presumptions inferred by title. Unless otherwise agreed that property is separate property, jointly titled property is presumed CP upon death or divorce, regardless if paid for with SP funds. Management and control. Fiduciary duties. Spouses contract with each other for the obligations of mutual respect, fidelity, and support. Spouses' confidential relationship imposes a duty of good faith and fair dealing. Community personal property, CPP. Equal power to manage CP. One spouse cannot gift or dispose of CPP for less than fair value. One spouse cannot sell or convey family furnishings without written consent. Community businesses. Managing spouse can make all business decisions but must give written notice to sell. Community real property, statute of frauds. Statute of frauds applies. Both need to sign to sell or lease more than 1 year. Cannot convey to third person without the other spouse's consent. Presumed valid to BFP as a bona fide purchaser. If done, spouse can void sale within 1 year. Non-BFP can be voided at any time. At divorce, generally, money which would have been CP will be treated as CP. If it was meant to be SP, it will be treated as SP. Tracing source of funds may kick in here. This is a general note. Most of the time, the assets are clear as to which way they are split. But if something is off the wall or difficult to discern, just write it up whichever way seems best and move on. Prenuptial agreement must be in writing, made voluntarily, with aid of counsel, and not be unconscionable. Must be in clear language in which the party is proficient, presented with the agreement, and allowed 7 calendar days in which to seek advice of counsel. Prenuptial agreement came up once, and it was rather obvious that although both parties agreed to it, it was not valid due to the lack of seeking counsel or allowing 7 days in which to seek counsel before signing.